Hi, Sat Buchanan, congratulations. You can once again play that Vybes Kartel song and tell Miss Llewelyn to go and suck a dick. 119.
Highest standard. We know that there is going to be another hearing and the possibility of other things after that. The overriding objective in any criminal trial is fairness to the accused. And therefore, I have deliberately stayed away from making any public comment about the judgment, save and except in respect of that narrow area of law where the possibility of the amendment to the Jury Act to replicate Section 46 of the particular legislation which was referred to by the Privy Council.
Well, viewers and subscribers, this looks serious. This is a 50-50 chance. I don't have much to say because Jamaica right now is a watch and see. We have to just watch and see what go on in this case and this retrial. Because if Paula Llewelyn win, is a big legacy in our history, and if Vybes Kartel win, is another big legacy on him history and film side. So Jamaica, we have to just watch and see. The world I watch and see. Because you know we don't really want to say much. So want to listen, like and comment, you know, Paula Llewelyn, the DPP should just go make her talk today fresh. This come out today, so watch and see, viewers and subscribers. Is a watch and see what go on now. So you comment and tell me what you think. Okay, I'm your host, World Rhyme Up. Watch and see.
Their judgment would, I believe, go a far way in enhancing the administration of justice in Jamaica. What I indicated and what I would indicate, this case has had a particular history. There are a lot of things that have occurred, which I will not go into, which have caused us at the office of the DPP right throughout to have to be very, very careful and to refrain from making any sort of commentary on the matter which may be misinterpreted by either the accused, their attorneys, or members of the public who may not be totally informed of the legal issues and may seek to act in a negative way on given the emotions around the matter. When certain things are done, remember we have context that you may not have. We are at liberty to look at it through the lens of it perhaps being an issue, looking at what is being said and what is not being said, which can act as an inhibitor if we were so minded in respect of us continuing to robustly do our duty, as we do in this case and so many other cases all over the island. Well, I believe we would be obliged to, given the strength of the case for the prosecution that was put up, and given the authorities and the case law, perhaps, as I reflect going forward to my retirement next year, I have been too successful in seeking to, and I'm happy about it, to sensitize the public, to sensitize the media, to try to explain a lot of complex issues. Very often, and I say this, when you have knowledge of the state of the law in any particular area, for example, retrials, the prosecutors are obliged to go on a particular path because the law obligates you to do. Well, first of all, the public has to be aware that the issue of retrials, as far as lawyers, well, let me say prosecutors and the judiciary are concerned, has nothing to do with emotion. It has nothing to do with who the accused is. It has to do with the seriousness of the offense, the public interest, how perhaps expensive it may be to mount the retrial. It doesn't even have to do with what the likely verdict may be. But it has to do with a number of factors which have been outlined in what we would call the locus classicus from the Privy Council in a case called Dennis, the main case on the point. So even if you have other cases that have been decided in the Jamaican jurisdiction and other jurisdictions in the Caribbean, that case is always regarded as the case that is endorsed and is adopted, right, by the Court of Appeal. So it is the go-to case that any lawyer would go to first in looking to see what the Privy Council has to say about the guidance on retrials. So, as I said, it has nothing to do with emotion. Now, delay in the criminal law has been pronounced upon by many courts. The Chief Justice has a famous case called Mervyn Cameron in respect of the whole issue of delay. And although the delay was quite a few years, the Crown was still allowed to have the case tried, and Mr. Cameron was convicted. We have had cases where delay without more would function as an abuse of the process of the court. Were you to seek to try the case or to retry it, and the prosecution has no choice but to enter a null in the matter. So it will come down to both sides, as it usually does. We are in an adversarial system. We have the defense and we have the prosecution. We both, as lawyers, do our research. We put forward our submissions in writing, and then before the Court of Appeal, which would be consisted of 3 judges at this very high level above the Supreme Court, we put forward our arguments, we amplify them, and we sometimes are questioned by the judges, and then it is for them also doing their research to come down one way or the other, with reasons usually. So I have seen where retrials have been ordered, and I have seen where retrials have not been ordered. It all depends on the particular case, and you know that each case has to be assessed according to the particular law, and most important is the circumstances of the case. On the particular day, we have the open court system. The media, on behalf of the public, can certainly sit in patiently, listen to the particular arguments, and I'm sure in your usual efficient way, and I hope accurate, broadcast it to the public, and everybody will be able to hear what the arguments on both sides will be. And when the judgment is delivered, I am sure the judges, given the circumstances of this case, and given especially the fact that it was a Privy Council instruction or directive for the issue to be considered by the local court, they will give their judgment in writing. But first of all,
hey, what's up everyone? It's your boy EJ coming.
You know, it's funny, but I recognize, especially when I was in London the other day and just even speaking to maybe other DPPs in other countries, that you cannot avoid looking at the local culture of a particular place. When I saw the Beaches Stout matter recently, the Everton McDonald, and here again you had a case where trial was some 5.5 months. This is highly unusual in Jamaica, but increasingly we have been prosecuting more and more complex cases. And may I put in a plug and say that Jamaica is probably the only Caribbean country that where the prosecutors in the DPP's office consistently prosecute our own cases and appear in the Court of Appeal. If you go to several other Caribbean countries, these complex cases are farmed out to members of the defense bar who are made special prosecutors to try to do these matters. But our expertise sometimes no matter how young our staff is. And our office culture is for us to do our own cases, no matter what the risks are, no matter how dangerous they are, no matter how complex the issues. And that's a good thing, because we build up a capacity to do these cases. Now, in Jamaica, Jamaican jurors like to be able to go home to their home every day. That's my take on it. And I find sometimes you have attorneys, and everybody can have an opinion, but whenever I hear attorneys talking about sequestering a jury, which, just to explain to the public, is whether the case is 1 week in duration or 3 months in duration. I think they have it in some places in the American jurisdiction. You would be from day one be put up at a hotel, so you would not really be able to go home. That, I know, would not be popular here. You probably would never get a juror to serve. And whenever I hear attorneys talking about it as something that we should adopt, when I look at who the attorney is, invariably it is not an attorney who has an active jury practice where they appear before the jury a lot. So for example, in England, I will say, they may have a situation where if the matter is very complex, 3 months, 4 months in duration, the trial, the judge is going to sum up for 4, 5, 6 days. Maybe they may have a situation where they sequester, perhaps at the end of the day, because they expect the jurors to stay out for a day or many hours. In Jamaica, and I've been practicing for some 30-odd years, and I love appearing before the jury, the jurors don't usually stay out longer than 1.5, 2 hours. If they go over 2 hours, that is in the exceptional case. In the Beaches Stout case, for a 5.5-month case with summation lasting 5 days, the jurors stayed out for 1 hour and 10 minutes. That is part of the local practice in Jamaica. Jamaican juries make up their minds pretty quickly, and they don't stay long. Once they have made up their minds, they have discussed the issue. That's a part of the local culture. So persons who don't practice before the jury very often wouldn't really be aware of. I say this for the public. But I have always been a proponent of the jury system. Mm-hmm. I've always believed that, given the importance of the jury system, that we should not abolish it. We should have a hybrid. You have some cases that are tried by a judge alone, you keep the jury system. We are a small country, and as far as I'm concerned, once you have people moving around the jurors, unless, whether you're at a hotel, you have the persons who will be serving them their breakfast, lunch, and dinner. You have other employees at the hotel or the guest house. You have even the police officers who are supposed to be there guarding them. Once you have people, this is a small country, if people really want to get to a juror, then they can, as far as I'm concerned, because it comes down to the integrity of the jury, and which is why I was so congratulatory and celebratory of the jury in the Beaches Stout matter, because they stayed together in terms of coming to court every day for 5.5 months, and so committed and filled with integrity and knowledge of their duty. None of them dropped out, and we were able to finish with all 7 with no incident. And that is a great thing for the civic duty Jamaica. Remember, Ricardo, and perhaps I shouldn't say it, but it's a matter of public knowledge. I have seen it happen. I've been prosecuting cases. I've been prosecuting a case, murder and wounding with intent. And overnight, I'm eliciting evidence from a witness who was wounded during the murder. of the other person. And the police called me in the night to tell me, Miss Llewelyn, the witness, just called me. He hasn't finished his evidence to say that the accused man who is in the dock called him from prison to beg him not to give any more evidence in the case. So if you have a situation where persons, they can be out on bail, they are in custody and they have access to phones, people know people, people live in communities and know people, people work here, and they may know people who know other people who know the accused or who are sympathetic to the accused. We are in a small society. And, you know, you cannot ever, I think, in a small society like Jamaica, necessarily totally safeguard that. If you're going to sequester, I'm saying, given the local culture of Jamaicans, if you are going to sequester a jury for 3-4 months, you will never get a jury to sit. We're just doing a little bit more research, and we should do it by the end of this week. And let me make it quite clear, it is a common situation where sometimes the defense bar do it with the Bar Association. We may, as we did with the Firearms Act the other day, the new Firearms Act, we saw certain gaps because we are the practitioners in court. And we saw that there needed to be more refinement in 1 or 2 areas. And we make recommendations to the Ministry of Justice indicating what we saw happening on the ground or in the trenches in court, and why we believe we would need to have some amendment. And it is usually for the policymaker, who would be the minister, and the advice after his legal team have looked through it and has gone through the process to decide whether to go forward or not. And then the whole process in terms of it going to Parliament and the you know, it would take place. But I would invite you to do a poll and ask persons on the street, if you knew that you are going to be sequestered and you explain it, that you would be away from your family for a month, 2 months, 3 months in a case, would you volunteer to be a juror on the particular case? Underestimate, look at the locality. I'm not saying that if it's a case, maybe a week, 2 weeks, but in my experience, given the Jamaican personality, they would want to go home to be in the comfort and care of their loved ones. To do is to look at the integrity. This jury tampering is not something that happens often. Mm-hmm. In my experience, what I saw happen in the case, I've never seen that able to successfully prosecute somebody for attempting to pervert the course of justice. So it's not something that happens that often. By and large, the jurors in Jamaica act with integrity, and they are almost overwhelmed, and they take the fact that they are judges, supreme judges of the facts, very seriously. All the other factors, that some of which I cannot go into, in terms of thinking of security issues, there were a lot of other issues that we cannot go into the public domain. And what our information from the foreman was, what she was saying, was that all of the attempts had to do with acquittal. Acquittal. Clearly, if it had been the other way, we would have, clearly, given the overriding objective of any case, which is fairness to the accused. But what would have been perhaps planted in the mind of the jurors is, okay, you need to acquit. And remember that these persons, at least 2 of them, are very famous. So it would have been, as far as the prosecution, when we discussed it, we would have been at those ones at a great disadvantage. This is not the first time that I have had to deal with jury tampering. After 64 days of trial, done other cases where there has been jury tampering to the great negative of the prosecution. I have seen cases, I've seen jury inquiries where the juror, having been questioned, it was quite clear that it was either an accused person or an accused person's relative that approached the juror. And the juror was able to indicate to the court that it did not make any difference. He would still be able to have an impartial situation in his mind. I have had the experience. I've prosecuted many cases. And when asked, I have indicated that we don't have any problem. So in other words, we are prepared to take our chances and just try to make sure that you have a very powerful address. But this, what happened in a couple of the cases I've dealt with, didn't happen during summation. It happened before we got to summation. So I have had the experience before of jury tampering. And I have been asked before, what is my view, being the prosecutor in the matter? And even after the inquiry, it's a judgment. It's quite clear that you don't know if the juror is telling you everything about the encounter with the relative of the accused, but you are willing to take the chance nonetheless. So it has happened. I mean, both myself and Mr. Taylor, who was the prosecutor, we didn't drop from the sky. It's not the first case that we are both having to deal with. And in our experience, we have had to deal with cases where you have issues.
Now that the Privy Council has overturned the conviction of Vybez Kartel, it is such a pity that one of the heroes of this Vybez Kartel matter, Mr. Isaac Buchanan, can't even come out and talk in his official capacity as an attorney because them suspend the man law license. And the reason them suspend the man law license is so unfair. But I have one thing to say to Mr. Isaac Buchanan. I have one thing to say to you, sir. You remember that Vybez Kartel song where you did play for the DPP, Miss Paula Llewelyn? You remember that Vybez Kartel song? The one in which Kartel tell Miss Llewelyn to go and suck a dick. You can play that song for Miss Llewelyn again, Master. Cause you win, Master, you win. You beat her. And this case is Paula Llewelyn, biggest case of her career. But Isaac, you are the victor. Because Kartel soon come a road. So if you don't want to play this song publicly, if you don't want to go on your live or go somewhere publicly, go play it. If you're afraid to play it, because you don't want them, then disbar you permanently. You can play this song in your bedroom and dance to it and sing along because you are a winner. You can be proud. And I want you to know that Vybez Kartel freedom going to boost the entire Jamaican economy. Because there is not no one event can keep to celebrate cartel freedom. It has to be a series of events, 1 week of events right across the island. And people will be coming from all over the world. Every hotel gonna be full. Every restaurant is going to be full. Every Airbnb full. All the airline them a go book out. Because everybody a come. And money a go run. Every vendor sell off. Beer money a run. Who no see the power of music? Who no see the power of one artist? With government and corporate Jamaica. The bank, them and everybody no want pay no attention to music. Them look down upon music and frown upon music because it come from the ghetto and a ghetto people something. So they no respect music as an industry. But you see how one artist, Kartel, powerful, that in capture the entire internet and crash the internet. Me did predict say the internet a go crash when the Privy Council are going to deliver the verdict, and so said, so done. So music is very, very powerful, very inspirational, and have a whole lot of potential to turn around the Jamaican economy. People from all over the world are enraptured and captured with this Vybz Kartel matter, and it just shows you the power of music. We want to respect. And there are many more artists like Vybz Kartel, but we want to nurture them. We want to harness the talent. We want to invest in our music. I can think about someone like a Chronic Law who is as talented as Vybz Kartel, although he's not hero worship for some reason. But that man is a lyricist. That man is an exceptional poet, Chronic Law. But when not take the youth them and give them a chance, you know, if you say foolishness them I do. In every other country where, if any other country did have something like reggae music and dancehall music, then Retrial fight. But I don't want to talk about this politics, business, banking, official thing, anything where too informal and I don't like it. You see Korea have a music named K-pop. You know what Korea do? Establish academies all over Korea to teach people K-pop. And the biggest boy group in the world right now is a K-pop group. But we don't take music serious. So I sat back here and I am happy for you. Miss Paula Llewelyn, I know you don't feel good because you was betting on this one. And for those people who are confused and don't know what happened, when the Privy Council overturned the conviction, what it means is that Kartel and Sean Storm and everybody else, they are now innocent. It's just like you take up somebody off the street and you arrest and charge them and them waiting for trial. So them can go and apply for bail and be out of jail in another 2-3 weeks. And then the world will erupt in celebration. I know there is another side to the story. My condolences go out to Lizard and her family. And I'm not saying Kartel murder them. I don't know anything about that. Although some people are saying this and that. One thing 119 will say, this is 119's position. Some people sometimes deserve some things. Cause some people do some things where them deserve some things. People murder people all the while and get away with it based on them status. Them white collar, corporate people, tighty upper class, do all kind of thing and get away with it. And me know say, if you come catch a man a booger, your 5-year-old son or your 6-year-old son, and you murder that man, you are going to say it is justified, and that is 119's position. So, Paula Llewelyn, hush. I sat Buchanan, congratulations. You can once again play that Vybz Kartel song and tell Miss Llewelyn to go and suck a dick. 119.